Hi, folks. Denise Howell here. Evan Brown and I are going to bring you a great show next on This Week in Law. We've had lots of action at the Supreme Court this week with Riley and Aereo and McCullen. We've got free speech and First Amendment expert Sonja West from University of Georgia School of Law joining us. Also, internet lawyer Bennet Kelley is coming in too. We're going to talk about all the good speech and Supreme Court stuff, privacy stuff, and social web stuff. How on earth are you going to find a parking space in San Francisco? I'm going to tell you next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 265, recorded June 27th, 2014. Monkeys, ducks, and unicorns. Hi, folks, it's Denise Howell, and you're joining us for This Week in Law, and you're so glad you did, because this has been anything but a slow news week on the law and technology front. Law affecting technology, law affected by technology. Lots of good stuff coming out of the Supreme Court, some not so great stuff coming out of the Supreme Court, depending on your perspective on the decisions this week. Definitely interesting to try and unpack and talk about and forecast the impact of what the Supreme Court has done this week in its cases on cell phones, on Aereo, on speech. Lots of stuff going on there. And fortunately, as usual, we have a wonderfully erudite and educated panel to help you understand what's going on in this cutting edge area of the law. Joining us right now from the University of Georgia Law School is Sonja West. Hello, Sonja.
Hi.
Hi, it's great to meet you.
I'm so excited to be here. Like you said, great week. I love it when SCOTUS opinions come down.
Yes, it's always fun this time of year. Also joining us, returning to the show, thank you so much for coming back, Bennet Kelley.
Great to be here. From
the Internet Law Center and the Cyber Report show. Bennet, I know you do the Cyber Report. Is there another media outlet that you do that I'm spacing on right now?
It's on Webmaster Radio and webmasterradio.fm, but we recently were picked up by iHeartRadio.
There we go. Wonderful. Another great show about the kinds of issues that we talk about here on our show every week with my co-host, Evan Brown, who's back this week. Yay. Hello, Evan. Good to see you.
Hey, it's good to see you. It's great to be back. And Bennet, wonderful to see you and talk to you again. You were so gracious to have me on your show at the end of last year, at the end of 2013. So I really enjoyed that. So it's good to talk with you again. And Sonja, very nice to meet you. This should be a really fun conversation today.
Yes. And let's start out with the Aereo case. As I was saying before we started the show, I just need to get this one out of my system early on in the show. So let's do Aereo. All right, so it's been a very long wait and decisions winding through various courts involving various parties before we got a definitive and controlling decision on whether organizing a business around pulling down live over-the-air broadcast TV with tiny dime-sized antennas and then streaming it out to your customers would be legal under U.S. copyright law. And what the Supreme Court found this week is that it's not. The Supreme Court found two critical points in its rather lengthy, about 35-page PDF opinion, that's including the syllabus and the dissent. It found two critical points. One, that there was actually a performance of the copyrighted works going on, and that was the mostly technological discussion of the show, of the opinion. The opinion is quite a show. I recommend reading through it if you're interested in this issue at all. And then the second critical point that the Supreme Court made was that it was a public performance. And if it's an unlicensed public performance of the work under copyright law, that's infringement. So this means that Aereo pretty much is done. I was speculating while reading through the opinion whether the DVR function might still survive, and we can talk about that a bit. Other people were speculating about that too. But I think on balance, it's probably done, as are other technologies that might have tried to deliver broadcast television in this way. So there, in a nutshell, is what happened. And let's try and get to the why and what it means. Bennet, we'll start with you. What do you think of the decision and the court's two key conclusions about performance and public performance?
I actually disagreed with their conclusion that it was public performance, and mainly for the reasons I thought that Scalia spelled out well in his dissent. There's a big difference between the precedent they drew upon, where someone is downloading a whole body of work, where here they're only streaming video as directed by the consumer. And so I thought lumping them together, it just wasn't appropriate. I mean, as I mentioned to you in the note, I mean, basically, it walks like a unicorn and talks like a unicorn, so we'll call it a duck. Ultimately, I didn't think the court really spelled out how as compelling as the dissent did as to why the ruling should have gone that it wasn't a public performance.
Evan, as we've been watching this case unfold over the years and wind its way through the courts, you've expressed the sentiment in the past that using the dime-sized antennas as your technological means of getting around copyright law might not sit well with the court. And in fact, the court, Justice Breyer, writing for the court's majority, did seem to just want to sweep under the rug what was going on behind the scenes, as he called it, that really wasn't important. You could do whatever you want behind the scenes, but if it's functioning in a way that looks like a cable system, as the court decided this was, then we're going to treat you like a cable system, and you're going to have to pay the same sorts of fees that cable systems do. Do you think that the court decided the technological end around, this was a technological end around of the law, and that shouldn't be tolerated?
Probably. I think that's what happened here. I mean, we see from the opinion a good indication that it was just as Justice Scalia in the dissent characterized it, a results-driven ruling. It's as if the justices decided how they wanted to rule beforehand, and then look at what the text of the Copyright Act says and fashions a way to get to that end result that was determined beforehand. And unfortunately, courts do that from time to time, and it doesn't always end up with the best decision. At a fundamental level, like many people who are watching the show and listening to the show, I am really disappointed that the court ended up where it did. But at the same time, I'm not surprised at all, because look at the ridiculous situation that the court really is in. In having to answer this question. It has before it an extremely innovative technology backed by millions of dollars of venture capital funding, parties here on the Aereo side really wanting to do something new and innovative and make a lot of money from it, sure. And then the other hand, the court has in front of it this rickety old structure, namely the Copyright Act, which the language that we're talking about here, the definition of what it means to perform a work publicly, and more specifically, what it means to transmit, whether or not that, under what circumstance that performance is public. That language was fashioned in response to earlier court opinions that were dispensing with technology from the late 1960s and early 1970s. So right there, it shows what a ridiculous practical situation the court is in. So it should come as no surprise if the court can determine what kind of result it wants to get, to look at it then and see, well, Aereo, what it's doing looks like a cable company, looks what a CATV, a community access television provider, does. If we look at the regulatory intent of Congress when it was enacting the 1976 Act, we're just going to say that Congress intended to cover everything that is anything with closely resembling cable companies and other situated parties. If just the final phenomenon of what Aereo is doing looks like that, we'll just go ahead and sweep that through. And then the language that the court has with the transmit clause and the right, the public performance definition, and the transmit clause is so skewed enough and so inapplicable that they can fashion an argument to fit it in. So I guess to put a summary on what I've said here, it's disappointing, but I really don't think we should be all that surprised if we can take as a given that the court very much wanted to see this as a cable company from the beginning.
Yeah, that came through pretty loud and clear in the oral argument on the case. Sonja, what's your take overall?
Well, I think what you see here is, in addition to everything everyone else just said, is some issues about the court trying to deal with this new technology through this method of analogy. And we see this also in the cell phone case, which we'll talk about in a little bit. But when we have Justice Breyer writing from the majority saying this sure looks like a cable company, you pick a show, you watch it, it seems kind of like just watching cable. And then you have Justice Scalia in his dissent coming in saying, no, it's more like a copy shop, which I don't think those even really exist anymore. I don't know if Kinko's even around, and as you were saying. And then it kicks it even further. It's a copy shop in a library or with a library card. It's clearly just a very problematic way to try to decide these kinds of cases, and it gets us into this uncomfortable situation of picking substance over form, and instead of having the court actually try to interpret what the statute says, and also even taking into account sort of congressional intent to the extent that is something the court can do and something that's appropriate, that we're getting away from sort of this congressional intent of a copyright law that is meant to protect creators by having these very strong protections for distributors of these creations. And so are we really even furthering this congressional intent? And also I find it just interesting how we've come to look at broadcasting, that broadcasting, of course, is this content that is free, that we have a history of broadcasting law where we give licenses and we think that there are duties that come with those licenses. It was just 20 years ago that Congress was, passing must-carry laws, telling cable companies they have to carry the broadcast license because of this fear that they were going to, just push out the broadcast stations, and suddenly now someone who uses this mini antenna behind the scenes to get their broadcasting is a thief, and people are looking at it in this very different way. So I think it is a problematic decision in a lot of ways, in terms of its copyright, how it interprets the copyright statute, but also in terms of just their method of analogy, their method of approach of interpreting these statutes is just going to hit a lot of roadblocks if this is the way they keep going.
Yeah, one of the funniest examples to me of that in the opinion comes in the portion where Justice Breyer is discussing and concluding that this is a performance before he gets to whether it's a public performance. He's analogizing both to older technologies and to cases that have resolved the question under older technologies. And it basically says, well, in the early 70s, when these cases were resolved, you could select a channel by turning a knob on your television. And so this is just the same kind of thing where you're clicking something on a website, turning a knob. It's the same. I really did not expect television knobs to play a large role in the resolution of this decision. And yet there they are. So yeah, Sonja, I totally agree with you that this is a rather clumsy way to try and apply the law to what was going on here. And I wonder, your comments make me think, Sonja, although the court doesn't come out and say this, it does talk about how the court made decisions in the 70s that Congress set aside and that the court, through the 76 Copyright Act, and that the court now has to abide by its terms, and that's what it was construing here. I'm wondering if this is basically punting back to Congress and saying, look, if we're going to have the ability to distribute free over-the-air broadcast television in a way that's not a cable company, if we're going to make some new cable company distinction for new technologies, Congress is going to have to recognize that and decide what to do with it. And maybe if Congress does that, you won't need to have little tiny dime-sized antennae to accomplish it. You could do it in a more streamlined and efficient technological way too. Do you think that that's a conclusion to be drawn from this opinion, Sonja?
I mean, it's possible, and I'm sure that, there will be pressure now in Congress to do something. They didn't say that. I mean, sometimes they just come out and say that. They say, we are just going to push this back to Congress. They didn't say that. In fact, they said the opposite. They said, we're pretty sure we know what Congress meant, and they didn't mean this. And so we're going to respect what it is we're pretty sure Congress meant. They didn't seem to me explicitly to be saying, it's your turn now, Congress, fix this. They seem to think we're doing the right thing based on how they interpreted the law and what they thought Congress actually did intend. I mean, they could have done it the other way and said, based on what we have written here, this is fine. Congress, if you think this isn't fine, change something to let us know. But they didn't do that either way. It seems very definitive to me, the way I read it.
And, that's how Scalia really comes out looking pretty grand in this. Just, one of he in the dissent clearly articulates, I think, what a lot of people would have liked to have seen be the majority opinion. And he devotes a whole section to his dissent on this idea of guilt by resemblance is what he calls it. And he, he finds, it's the simple, you got to love Scalia in his writing. He says the court's conclusion boils down to the following syllogism. One, Congress amended the Copyright Act to to overrule our decisions holding that cable systems do not perform when they retransmit over-the-air broadcast. So change the idea of what it means to perform. Aereo looks a lot like a cable system, therefore Aereo performs. And then he points out how that has three big problems. And the first of which is that it's built on this very shaky foundation of what the congressional intent really was. It says the court, it reaches out to decide the case based on a few isolated snippets of legislative history, which, as you'll see in the majority opinion, it does rely very heavily on what the Congress people, the members of Congress were talking about. It says the court's, this is the part that I love, the court treats those snippets as authoritative evidence of congressional intent, even though they come from a single report issued by a committee whose members make up a small fraction of one of the two houses of Congress. So, there's the big problem there. That, generally, I thought courts, especially the Supreme Court, was supposed to look at the text of the statute first and then go to legislative intent if it's at all possible. But here, what we seem to see in this opinion is that, look directly at what the court or at what Congress intended and took it as gospel that the intent of what was in the mind of Congress, which in itself is sort of a fallacious way of thinking of this, still exists and should still be given embodiment in a 21st century technology. It just really does seem quite odd. And you can see why Justice Scalia would get upset about the way he likes looking at the texts of statutes.
Right. Well, we could spend the whole show on this case, but there were a lot of interesting developments this week. So I want to hit some highlights of the decision, really just throw them out there as food for thought and look ahead a bit at what it might mean. We've been talking a lot about finding that it's a performance. It also critically found it was a public performance. That part, I have difficulties with the entire opinion, but the public performance part in particular, I think is hard when you look at, again, the court was not relying on legislative history here, as Evan was mentioning. I just pulled up the transmit clause, and it's kind of long. I want to find the part that I'm referring to here.
It comes from a part of the definition. I mean, we've got three different parts. While you're finding that, I mean, we've got to look at three different parts of Section 101 of the Copyright Act. I mean, there's the definition of what it means to perform, And under Section 106.4, one of the exclusive rights of the copyright owner is to perform it publicly. So then there are other definitions about what it means to be public, that performance, and that's where the transmit clause comes in, which hopefully
here's that part. To perform or display a work publicly means to perform or display it at a place open to the public or at any place where a substantial number of persons outside of a normal circle of a family and its social acquaintances is gathered, or to transmit or otherwise communicate a performance or display of the work to a place specified by Clause 1. That's what we just discussed. So your living room, basically, or to the public by means of any device or process, whether the members of the public capable of receiving the performance or display receive it in the same place or in separate places and at the same time or at different times. So the court decided either that sitting at your home watching TV is somehow a public performance space, or that Aereo's customers comprise the public. And I'm really, still unclear, having read through the decision, which of those points the court is hanging its hat on. But in either case, I have a hard time considering Aereo's customers as the public. Bennet, can you shed any light there?
No, and I think that's the point that Scalia hammers home. I mean, how is this different than a DVR performance? And so I think that's what the court got wrong. And keep in mind that it's long, but the Betamax case was a 5-4 case. That was a tough decision to make. They took on the entertainment industry, and five justices decided that this is the way the law is, and technology is going to evolve, and we'll see what happens. And Congress is free to step in, and I think that would have been the appropriate thing to do here. It's unlikely that a startup like Aereo is going to get Congress to step in. Obviously, the motion picture industry and the others with vested interests aren't going to, they're going to block whatever they do. So the real policy-wise and courageous choice would have been to go with the dissent.
Right. Eric Goldman characteristically has a brilliant summing up and sort of, here's what you should be thinking about post over at Forbes. He calls it 4 unanswered questions from Aereo's Supreme Court loss. Let's wrap up our discussion by considering his unanswered questions. The first one is, and he says the court leaves this unresolved. I wonder if you guys agree that who took the legally significant action, whether it's Aereo or Aereo's customers, ever got resolved in this case, and does it matter? So, Evan, what do you think of that one?
Well, this is where the Aereo decision does sort of depart from our ordinary thinking when we think of it in terms of internet law or as an internet law issue, because, again, the court considered 2 questions. Was there a performance, and was that performance public? And in characterizing it as, yes, Aereo as the intermediary here, remember, the court held that it did indeed perform the work, and so that it could be directly liable for copyright infringement. So this is different than Betamax, and this is different than Grokster, in as much as in those situations you were going after the provider of the device or the service, the platform, as in Grokster, the intermediary for secondary liability. So here, we've got Aereo being treated as the intermediary, the provider of the service, in the question of its liability for direct copyright infringement, it being the one to take the act that constituted infringement of the copyrighted works owned by the networks and the broadcasters. So that is one thing that's really at the first blush very shocking about this, and the part that could, if there is going to be any effect on industry and the marketplace, it'll be that question right there, because what this case does is expand the class of providers of services, which could in some senses be thought of merely as online service providers as defined under the DMCA, for example. They are now are at greater risk of infringement for direct copyright liability for direct copyright infringement. And a point that Professor Goldman makes later on is like, well, maybe even this won't result in greater liability for those intermediaries, but you can be certain that there's going to be a lot more litigation in this space, just like there was just like in many more copyright cases now, you see inducement post Grokster. So Aereo wasn't the one who instituted the action. It didn't undertake the volitional act, the volitional conduct. And this is what I see as the real thrust of Scalia's dissent. Aereo is just the provider of the services here, yet it is being held directly liable because, well, it looks like a cable company.
Right. And to that point about there being more litigation, this is existing litigation, but the case is already being raised by Fox in its case against Dish involving its Hopper and streaming services, has already run to the Ninth Circuit, saying that in light of this decision, Dish's streaming is going to be a public performance that violates. It seems like here there might be a twist because they have some contractual bars against streaming the works. So that's one to watch, but it's already coming up in people's litigation where someone's going to say, "Hey, under this case, you've got a public performance on your hands." I'll take the next one from Professor Goldman's article. Is the DVR as a service legal, either the aspect of Aereo's business or, say, a DVR under the Cablevision case, the Cartoon Network versus CSC case, as it's captioned, like the Betamax case, which has a different caption, Sony versus Universal, can confuse people. It confused me when I was searching through the opinion. I'm like, wait, where's Cablevision? It had to have come up. I wanted to go right to that discussion, and I couldn't find it because, of course, it's not called the Cablevision case when a court cites it.
Well, I don't think the majority does cite it anywhere.
Actually, they do cite it, but they treat it, they just blip right over it.
Okay.
And they also make a point at the beginning of the decision to say, let's see, did I quote this in our little rundown? Yeah, it went out of the way to say that the DVR aspect of the business was not before the court. Their specific language was the subscriber may instead direct Aereo to stream the program at a later time. They were talking about how it plays in almost real time. But that aspect of Aereo service is not before us. So, careful to keep their hands off the DVR aspect. But I don't think personally that the DVR aspect could survive this decision. And that's what Professor Goldman's question was. Cablevision actually contacted him after he published his Forbes post to say that they thought the opinion protects their DVR service. Their press statement says, "We're gratified that the court's decision adopted a sensible middle ground, holding that unlicensed retransmission services like Aereo violate the copyright law while protecting consumer-friendly cloud-based technologies such as RS-DVR." Professor Goldman goes on to say, "I don't read the opinion as charitably as they do, and I don't think I do either." Mike Masnick published something that hits on some language in the decision that the court uses that was contemporaneously perceptible. And Mike thought, well, okay, so that must mean if the images and sounds that must modify by people watching. So contemporaneously perceptible by multiple people would equate to a public performance. And if Aereo or some other hypothetical service just use some kind of algorithm to ensure that nobody could be watching the same program at the same time, then maybe they've got a legally viable service on their hand. As I read through the opinion, I don't think that's what contemporaneously perceptible modified. I think the court was talking about sounds and images comprising a performance being perceptible together. That was what was critical for the court in finding that there was a public performance. And so I don't think that just separating the viewing by the customers is going to pass this court's test. Really fascinating question raised by Professor Goldman. I'll kick this one to you, Bennet. Is the impact of this case on inline streaming? Professor Goldman posits that since we're just not going to look at the technology behind the scenes, if it looks like a unicorn and sounds like a unicorn and is a duck, then maybe inline streaming is a duck too, because it doesn't matter that everything going on behind the scenes technically makes it not a copyright infringement. What do you think of that one, Bennet?
I mean, and that's the issue. I mean, the fact that saying that we're not dealing with DVR type service. Well, how does DVR aspect of Aereo survive? I think the Supreme Court decision is definitely going to hurt innovation in this area. It's going to make it much harder, and it's anti-consumer. I mean, this was something that benefited the consumers, and I don't think it's really, they spelled out it in a way so that future people venturing into this space have a roadmap for how to do this without violating copyright laws. More or less, if they do something that looks like it's a cable system, they're going to get nabbed. And so there really isn't how do you innovate around that?
Yeah, the tragedy of that, maybe having tiny dime-sized antennas is not the most technologically efficient way to approach this problem, but coming up with new ways to approach delivery that work better than the systems that are in place now is something that you would think the law would want to encourage. And whether, this particular one is it or not. And I fear for what this opinion will do to coming up with such technologies, even on behalf of the cable companies, if they were to want to take a different approach toward delivery of their content. They may find themselves hamstrung by this decision, which leads to Professor Goldman's last question. Will this opinion chill innovation? What do you think, Sonja?
Well, that's always the concern when you have, the advantage of formalism with Supreme Court opinions or legal opinions in general is that people are all on the same page. They understand, here's the text, this is what we're supposed to do, this is what we're supposed to follow. But when the court says, but if it kind of looks like a cable company, at least to the uninformed user just sitting there, then we're going to call it a cable company. Suddenly, all bets are off. And so we could have innovators out there who have come up with new ways, or in the future will come up with new ways that they say, well, I look at the text of the copyright law, this looks fine to me, but to someone sitting on their living room couch, it might look like a cable company. So am I in trouble now? And should I continue investing time and resource and my expertise into innovating this new technology? And so that's definitely the harm that comes with the court, again, choosing substance over formalism in this kind of situation.
So the question that kept coming up in the run-up to the case, and that I think remains unanswered now, along these lines is, okay, so your Dropbox or your Google Drive or your anything that stores customers' data in the cloud without doing close packet inspections and content ID matching of that data. What do you make of this? Are you now in jeopardy, you and your cloud service? What do you think, Sonja?
To me, that's the $1 million question. I just wish I know. The court went out of its way to say, this isn't going to apply, or we don't think this applies to any other kind of cloud-based computing or streaming. The court sort of charmingly, one might think, went back to a 2008 dictionary to tell us what streaming means, and so they tried to carve that out, but it's a little hard looking at the opinion to know truly, what is the future there. I don't have the answer.
Well, as I said, we could talk about this particular decision all day, and we will have to just watch as these questions and their answers unfold for us. And I'm sure we'll be talking about the case more in the future. But right now, let's go to another very interesting Supreme Court decision issued this week that impacts privacy. So an open question in the law for quite some time had been whether the law enforcement, police officers could search your cell phone incident to an arrest without a warrant, much like a sort of unrelated issue that we talk about a lot on the show, whether you can be required to give over encryption keys in connection with government or law enforcement investigations of you or something where you might have evidence. This is your phone incident to an arrest. The Riley case said your phone cannot be searched without a warrant. So we now have a definitive statement on that point. Some good reasoning from the court about the role of portable technology in our lives and what people actually put there and why this is something that's more prone to needing privacy protection than anything else that might be around or on you in the course of being arrested. So now we have some clarity on this point. I think Oren Kerr, again, somebody very educated and insightful law professor, giving us some good food for thought after the decision, what we should be thinking about, and reading the court's treatment of cell phones and the data on them, says, I think Riley can be fairly read as saying that computers are a game changer. We're now in a digital age, and quantity of data and the qualitatively different nature of at least some digital records changes how the Fourth Amendment should apply. He also says it makes little difference whether the information is inside your pocket or on. Oh, this is going on to another point, so I'm going to raise that in a minute. The extent to which this decision may impact cloud stored data as well. But let's start first with just the notion of needing a warrant to search your phone. The court was unanimous on this one, and it seems to be hailed by everyone except law enforcement as a good and well-reasoned decision. Evan, what's your take?
Well, it's interesting to see such clear guidance on it. I think I'm a little bit surprised about that this was a unanimous ruling. I mean, there was one concurrence by Justice Alito who took issue with sort of the pedigree of this idea of the reasons for a search incident to an arrest. And that's the context we're talking about here, whether or not it's reasonable for the cops to search your phone in a search incident to arrest. This is when you're already been placed under arrest, doing that without a warrant. So in a certain sense, it's a sort of a narrow question, but it's still one of great importance here because a lot of people who get arrested have cell phones, and a lot of people carry cell phones, mobile devices, smartphones that have this all of this information in it here. So, I mean, it definitely is. I mean, I'm certainly not going to quibble with the way someone like Oren Kerr would characterize it as being a real change, or at least a clear declaration that the courts are willing to look at the digital content in a qualitatively different way. We sort of saw this foreshadowed in the concurrences in the Jones decision. That was the GPS omnipresent surveillance case from January of 2012, where the court held that was a Fourth Amendment violation to put a GPS device on somebody's car without a warrant. Majority Justice Scalia, our hero in the Aereo case, in that situation wrote the majority opinion. We're saying that it was a property interest at stake, but Justice Sotomayor in particular, not so much one of our favorites with the Aereo decision, but in that decision talked about this idea of things being qualitatively different because with all this information, you can get such a more higher resolution picture of what someone is doing. So particularly what happened in Riley here was the refusal of the court to extend this rule that once you're under arrest, you essentially lose all privacy rights over everything that happens to be on you. For example, there was this case called Robinson that talked about this, where the cops found a cigarette pack in the guy's pocket, opened up the cigarette pack and found packets of heroin. That, the ruling why that was okay without a warrant and wasn't a violation of the Fourth Amendment was because, well, once you're under arrest, you can't really expect kind of privacy within or about the stuff that's in your immediate area. And there are two or three different cases about all this here. But the courts recognized, we cannot extend that same line of thinking into digital devices because of all the information that happened to be on there. And moreover, there's this indication that there's a recognition by the court that not only is there that information that's on the phone itself, your contact list, your photos, your stored emails and all that stuff, but there's the ability to access data stored on servers elsewhere, which, as Oren Kerr very aptly points out, is this foreshadowing then to a decision from the Supreme Court sometime in the next few years that you do indeed have a Fourth Amendment expectation when it comes to data stored in the cloud. So some pretty intriguing things that the opinion actually says along those lines, and some things that could be, going in the justices' minds in the near future as well.
Right. He calls out language that it makes the court says it makes little difference whether the information is inside your pocket or on remote servers, and the contents in the pocket. If the contents in the pocket are obviously protected, it would be pretty shocking, Kerr writes, that if the court thought that the contents on remote servers aren't protected too. So that might, again, it wasn't before the court in this decision, but it might lead to some clarity on to what extent a warrant is required to get at, say, your cell phone records of calls you made, and also other cloud stored or remotely stored data in the hands of third parties. Sonja, anything you want to add to Riley?
Yeah, well, I think Riley is interesting compared to Aereo, where we see this struggle to sort of analogize to something we knew and are familiar with for the last 20 years. Here, the court refuses to do that. We have a body of Fourth Amendment law that is based on physical evidence and, to some extent, eyewitness evidence, and the court basically says, no, we're not going to apply that here. This is different, and we're going to recognize this is different. And the court, and it is, I think, Oren is correct that this is about computers, because the court flat out says we call them cell phones, but they're really these many computers that we carry around. So yes, it's a computer, and computers are just quantitatively and qualitatively different. There's just far more information than what it used to be, which is they could take out your wallet and you might have some pictures and you might have a bunch of receipts jammed in there or something. But there was just a limit. There was just a physical limit to what they might learn about you through that search, and that this is just on a different plane. And so the court was really quite comfortable in a way of stepping aside from the analogies of the past and saying that this is different. I mean, it is tied to our Fourth Amendment law in that we typically have a requirement for there being some sort of showing of potential law enforcement danger to law enforcement. And they're saying that's just not here. But they also clearly are recognizing sort of this immense privacy interest that there's just so much they could learn about you. And then, of course, there could be even beyond just sort of the data that might be stored there. It might give access, as said. You might have an app on there that lets you look at have a camera in your house, and now suddenly they can see your house, or however it is that the limits are just so much more than what we had before. So the court was willing here to realize it was different, and that makes it, I think, very exciting. And the fact that they did that unanimously, I think does show that they are recognizing both a privacy interest here that's stronger than perhaps what we've seen them do in the past, and then also a new approach and going into viewing computers with eyes open. And the lower courts have been heading this way for quite some time. This opinion was consistent with what we've seen going on in some lower court decisions, but it was very refreshing to have the court sort of so unambiguously embrace this view of computers and privacy.
So you're so right about the court's willingness to look, to embrace it from a new perspective with the digital context and not use any old analogies. And one analogy I can think of them having made, an old time analog analogy, is to draw that distinction. I thought this was interesting, and let's see what you think about it. Where they said you could actually learn more about a person by searching their cell phone than what you could ransacking their house. The Schimmel case is one of the big, cases about search incident to an arrest here. And the facts that were there, the guy got arrested. And so they searched the whole house, including the attic, the garage, pulling out drawers and all that stuff. And that was an unconstitutional search. But then you've just got this tiny little area in this device where there's all this information that you indeed could learn more about a person than by ransacking their house. Just, for example, where they have been, any kind of geolocation information that is stored in that phone. So it is, it's more than just a pronouncement to say that it's qualitatively different. I think if we think about that, it really is true, don't you think? Sonja?
I do. And I think, too, that they seem to be focusing sort of on this idea of quantity. It used to be we'd say, okay, the police can search your pockets and we let them pretty much search your car. We've been pretty open about that. But you're right. They say, but we don't let people go search your house. The police, law enforcement go search your house without a warrant because that's just quantitatively, it's just so much more. And the computer that we have in our pockets these days is more similar to your house or your bank records or your health records or everything that could be on there. So I think it also, to me, says something about how they might look at some metadata cases that are really just about quantity, and that could come out someday in cases about the NSA and just issues about what these companies can do when each individual bit of information doesn't seem particularly invasive, but the quantity of it together does seem to be bothering the court here.
To the point of contrasting and comparing this case to Aereo, one of the funniest tweets I saw in the wake of the two decisions coming out on Wednesday was by Professor Jeff H. Jarvis, not to be confused with our Jeff Jarvis, who tweeted, "Could Aereo hide all its antenna inside phones so the police can't search them?" So I suppose maybe that would be the solution. We should probably put an MCLA passphrase into the show. I think I'll make cue the band the passphrase because in chat, iBookery was asking whether Warrant wasn't a metal band, and yes, indeed, we got the answer that it is or was.
Cherry Pie, right?
There you go. That's right. So cue the band is our first passphrase. If you are listening to the show for MCLE or other professional credit, this is a particularly good show to be doing that with, I would think, with our illustrious panel and the great topics and trying to understand exactly what has unfolded this week. If you want more information about MCLE or other credit for the show, head on over to the Twit Wiki, wiki.twit.tv, find our show there, This Week in Law, and there is a ton of good information aggregated on the various states and their MCLE requirements and how we might fit into them for you. So let's see. We've got Bennet back just in time. Had a little technical glitch there with him, but he is back. Bennet, we've been talking about Riley and just the fact that search incident to an arrest now requires a warrant to get at data on a cell phone, and the court's reasoning on that. One thing people should bear in mind, though, is they can still put a passcode on their phone or their computer if we're going to assume, like or incur, that this reasoning would apply to all computing-like devices you might have with you during an arrest. And the passcode would prevent any access until someone had obtained some sort of court order or warrant requiring you to fork over the passcode, which is an entirely different legal issue. Do you think that the passcode or encryption key issue is impacted by this case?
Well, it was raised by the state of California in the argument that one of the concerns was that unless you did this, they still have while you're going through the process of getting a warrant, they still have the ability to hack into their phone and delete stuff. And there's different codes, ways you can do that. And so their argument was that the whole debate is whether this is an exigent circumstance. Once you have the phone, is it secured or is it still at risk? And the state of California tried to argue that we need to get that right away. And so I think that that's how that was addressed. Now,
so you're talking about doing something like a remote wipe on your phone while it was in the possession of the police.
Yes, and so that was the concern raised by the Attorney General. And I also think it's one interesting point is that I think the ruling confirms what I call the Mickey Rourke rule. And I don't know if you ever saw the movie Body Heat, but there's an important scene in the movie where William Hurt plays a lawyer who's in a love triangle. And Mickey Rourke is a client he helped get off earlier in the movie, and he's going to him near the end of the movie, asking him how to build a bomb, obviously to take care of the third wheel in the love triangle. And Mickey Rourke repeats some advice that Hurt had given to them earlier. And he says, anytime you go to commit a crime, there's 50 mistakes. If you're a genius, you can think of 50 mistakes that you make. And no, actually, anytime you're going to make a crime, there's 50 mistakes you can make. And if you're a genius, you think of 20. And believe me, you're no genius. And, this crime, in this incident here, these are gang members committing crimes and then taking pictures of it. And then carrying the process by which they took that evidence with them. And so, I think it's a further validation of the Mickey Rourke rule that somehow criminals often do stuff that just makes it easier for them to get caught. But here, the court made the right decision. The court, cops can still get access to that, but they have to get a warrant.
Right. Evan, you weren't with us last week, but we did use the story that you sent me about the guy in Florida who was Instagramming his illegal stash of weapons and got apprehended. So, yes,
I love that.
It raises a good point about this decision, and I haven't read this one as closely as I did the Aereo case. But I wonder, you guys can fill me in if it came up or not. It seems somewhat ironic to me. Now, I'm very happy with this decision, and I'm glad that it was reasoned and concluded the way it was. But it's still really ironic to me that we're talking about the high privacy value in your phone and other mobile devices when we live in an era when those devices are the things that people most use to dispatch their privacy, to do away with it. But of course, they do so volitionally or idiotically, as in the case of the guy in Florida or the person in the Riley case. So I don't know if that's neither here nor there, but it strikes me as really funny that we're talking about the high privacy value in these devices that, when they did not exist, people had a lot more privacy. So I tossed that out there.
It underscores the power. I mean, I don't know if you would necessarily have to characterize the court's decision as relying on the high privacy value. I think that's just the natural inclination, the natural conclusion to jump, because it is the Fourth Amendment. So we think in terms of privacy, and they probably say privacy somewhere in there. But really, if you boil that down to a more fundamental level, more general level, it is just the power that these have, by which you can communicate with so many people, generate so much content, so many different kinds of content that tell different aspects of the story. So that's where you can sort of resolve any irony there, is just by saying, wow, you can do a lot for good or for ill with these devices, whichever you choose.
And we should highlight the exigent circumstances exception that remains in place after Riley. There's a good article on this. I'm going to, all of the stuff, obviously, that we're discussing today, you can access in our discussion points for the show. They're available at delicious.com/thisweekinlaw/256. And, we're 265. Sorry, I got a little verbally dyslexic there. Anyway, the police still have the right to search your phone without a warrant if it's a child abduction arrest. They can still do it then. If they suspect that someone is in imminent harm or there's some imminent threat of evidence destruction. There will probably be lots of litigation about that point, how you demonstrate what's an imminent threat of evidence destruction, particularly given what Bennet was saying a moment ago. Don't you think, Bennet?
Yeah, I think that is the important point. And but you can take steps, you can take measures, and you just get a warrant and get access to it.
Right. So yeah, I mean, you're going to have to, I guess, extrapolating from what you've said about what the state of California argued, Bennet, it would not be sufficient for a police officer, law enforcement agency to come in and say, hey, there's an imminent threat of evidence destruction because Apple allows you to remotely wipe your iPhone or whatever device you're using and whatever might be available. That wouldn't be enough. Do you think?
No, I mean, unless there was some new advance in technology. I mean, this requires planning ahead. And going back to the Mickey Rourke rule, I don't think these are the type of people that plan ahead. I mean, some of them might. some of them might have that capability. And so, yeah, I mean, if that becomes an issue, maybe there's something, a countermeasure they can take to prevent access to it. Maybe just taking the battery out or something, so that it can't be accessed. I think those are all possibilities. But an important point was that, and this was raised in the First Circuit decision, was that at no point did they think this phone was a threat to them. And the reason for making these exceptions instant to arrest are because of the need to preserve evidence from destruction, but also to secure, make sure that the crime scene is safe and the police aren't at risk. And so the small possibility that the perp may have the capability of later hacking into it, I don't know if that just outweighs the privacy interest.
We probably, while we're at it, ought to make it a de facto rule that if you're investigating a federal employee, particularly at the IRS, and you think that their electronic data is going to be destroyed, you ought to be able to get at that right away. I don't mean to say anything about Lois Lerner or anything like that, but just probably ought to be good practice. But just put that out there.
Right. All right. Well, I think we're going to move on to our next big topic of discussion for the week. Since we have Professor West with us, and this is very much in her wheelhouse, we're going to talk about federal shield laws and who the heck we think of as a journalist these days. There's going to be some, hopefully, new legislation about federal shield laws. So let's look at what's going on in that policy arena. The federal shield law is something that lawmakers have been bandying about for some time. Recently, some news gathering organizations encouraged them to make their bandying more expeditious and effective. We still don't have a federal shield law. So, Sonja, why don't you start out by telling us your impressions of the proposed federal shield law that we might see sometime in the future, and your thoughts about whether we'll see it and when.
So you're right. This is an issue that has had legs for a very long time, really going back to the 70s. And we had then a Supreme Court case where some reporters tried to claim a right not to reveal confidential sources or to have to testify before a grand jury as a constitutional matter, as a First Amendment matter. And the court said that the court basically said, no, that opinion is a little bit open to interpretation. But for the most part, the court said, no, you don't have a constitutional right. So they had to turn to statutory means. And at a lot of state levels, we have had these shield laws saying that reporters or journalists or the press or however they're referred to, don't have to testify before grand juries about their observations, or they don't have to reveal confidential sources, or they don't have to turn over their notes or their if they're television or broadcasting, their outtakes, things like that. But we haven't had one on the federal level, although they have been raised many times. But we recently had one get through to the House, and there's pressure on the Senate to go forward. But there has always been this sticky problem with these, which is even people who really support these kinds of rights and protections for the press, we have to be able then to figure out who the press is, who are the journalists that would get to claim these kinds of rights. And for the most part, at least to a lot of people looking at this issue, that problem, that definition problem, has been one that's been so difficult that we've sort of just thrown up our hands and called the whole thing off. And of course, now today with sort of web-based journalism, it's even murkier than it was before. A lot of these state laws that I mentioned that were passed relied on the medium of communication to identify who was a reporter. If they assumed if you wrote for a newspaper or if you were on the radio or on television, there's a good chance you were a journalist, because regular people didn't have access to those kinds of mediums of communication. But that's just not the case anymore. Everybody is on Twitter, whether you're a reporter for the New York Times or you're just writing about your day. So we can't use that method anymore to try to separate out the people who are journalists and the press from other people. So there's been this sort of discussion about how we could possibly figure out who is a journalist so that we can give them these rights and protections that a lot of people think would be very useful things for them to have, but we can't give them to everybody. So that's really the dilemma that keeps coming up with the SHIELD laws.
Right, and the bill that is wending its way through the process now has a solution for that. It wants to be able to provide a judicial safety valve if there's someone whose status is sort of questionable, whether they should be entitled to SHIELD law protection. A judge would get to come in and say whether that person is covered under the law or not. So we're back to kind of the Justice Scalia guilt by resemblance issue. In fact, I think we should make guilt by resemblance our second MCLE passphrase for this episode of This Week in Law, because let's see, there's a good quote from Columbia Journalism Review. For the news organizations have said there's a safety valve for bloggers under this bill. If someone might slip through the cracks, it allows a judge to declare someone a covered journalist. That extra person gets to come in and say, if it quacks like a duck and walks like a duck, then it's a duck, not a unicorn. Do you think that, I know you've written an article on the topic of who is press, Sonja, a Harvard Law Review article that I've gone through not as deeply as I hope to. So I'm going to ask you to expand on some of the definitions there. But let's, as a starting point to getting into that, do you think that the proposed bill provides a good framework that will be able to get people covered who should be covered by the SHIELD law while not having it cover people who are what you would qualify as occasional public commenters?
I do. I think at least it's certainly a good start. I am sort of bothered by this idea of because we are afraid we can't do perfect line drawing all the time, that our solution is going to be to give no kinds of press protections for, usually this comes for the active news gathering. We all have lots of protections when we speak or publish. So really these issues are about the things that happen while a journalist is gathering the news, that you want access to something or you want protection for a confidential source or whatever it is. And usually our take has been, we can't figure out this line perfectly, so we're not going to give these kind of protections to anyone. And I think that's a great shame. I think it's a loss that we have for society as a whole. We're losing out on all sorts of potential news gathering that we could have. We're not giving the protections to the people who really are sort of day in and day out doing the functions of being a journalist, and that benefits everybody. But if we don't give them the protections they need, it comes at a loss to all of us and the news that we're giving. So first of all, I'm not quite as concerned of getting it exactly right. We do have to have concerns, however, of favoring certain kinds of speakers. And that's been a concern that's out there, that there's certain types of journalists who work for the traditional mainstream media. They tend to see the world one way, but then we have other people who are, more likely now to be bloggers. Someday they could use a different kind of technology, who are a different kind of voice. They come from a different kind of background. They have different things they want to talk about and news that they want and information they want to share with people. And we have to make sure they are covered too. So as long as we have, in my view, content neutral, viewpoint neutral kind of approaches to make sure we are finding the people who are informing the public and checking the government in a regular manner to an established audience, I'm comfortable with the courts doing that, and I'm comfortable with having the legislatures try to come up with a solution for that. I think we should at least try, because this way we get sort of more rights for at least some people and more of this benefit. And everybody else maintains these very, very vibrant speech rights that we all have. So we're not talking about taking rights away from anyone. We're talking about adding some additional protections for those who are really doing the work of informing us, gathering the news, and checking the government. And so I'm happy to see that this continues to get new information. And I don't think we should be so scared of the definition problem that it paralyzes us from doing anything.
Sonia, how does that work when you get the First Amendment into it there? Because I know the First Amendment has several different rights in it. It's more than just free speech. It's also the freedom of the religion. A couple of things there, and that religion stuff, and then freedom of the press is another one. I mean, how is the analysis articulated when it comes to these various questions? Is it one more of free speech or freedom of the press, or a little bit of both? What are the kind of like the outer contours of how that discussion is had?
So the First Amendment says Congress shall make no law abridging the freedom of, and for our purposes here, the freedom of speech or of the press is what it says. These are often referred to together as sort of the expression rights. But for the most part, all of our focus has been on the speech side of things. We have a very developed speech jurisprudence. We give very strong protections for the most part to speech. The Supreme Court has never found a right or protection to lie solely in the press clause, which is something that I and some others are critical of, suggesting that it has started to make the press clause of the First Amendment a mere redundancy, and I think it was supposed to mean more than that. In fact, when you look at some of the sort of original discussion about it, it actually appears that the press side of things was far more important to the framers than was, in the framing generation, than was the speech side of things. But they're both in there together, and you're right, along with other rights of religion and petition and assembly, and that's all together in the First Amendment. But it's been sort of a situation of the speech clause being, the court's favorite child, lavished with attention, and the press clause is the neglected one that has not gotten any attention. And the few times the court has considered it, it really has been this concern about how do we press right. First of all, can press rights go to everyone? And if so, they really start to look a lot like our speech rights, which also, our speech rights also include a right to distribute our speech and reach an audience, and we don't get anywhere else. Or if it doesn't, if it means something different, then suddenly we have a situation of trying to figure out who are the people or the entities that could have these rights and protection, and that's just it's scary to a lot of people. It's problematic that we might get into a situation of sort of government licensing and selecting on different kinds of information. So that is the concern, and that's what stopped, I think, the court from having a lot of press cases.
Right, because I guess what could happen is once we get this federal shield law, if it were to draw some kind of bright line, then you would have conceivably more problems along the lines of what we've seen, and you've been tweeting about, Sonja, with SCOTUS blog, the definitive blog that covers all of the developments and decisions of the United States Supreme Court, and has wrestled historically and quite recently with the question of whether it qualifies as press. In its case, it's not because it's trying to shield sources, but because of the various access that might be granted to someone designated press and might not be granted to a blogger. So it does cause me some concern that I've read enough of your article to grasp that the occasional public commenters you identify would not include someone like SCOTUS blog, but there are others that I think, are in that gray area who I might want to see have at least the legal and constitutional press privileges, maybe not all the access privileges, but if someone's just an occasional public commenter and they get some really sensitive piece of information through their public outreach and they have a source they need to protect, shouldn't they be protected?
Well, it obviously depends on the situation, but right now we're in a situation where nobody gets those protections. So nobody has this kind of protection if they get information from a whistleblower, or if they need to somehow violate what would otherwise be a generally applicable law because they're pursuing news. Nobody gets that. So I'm still talking sort of about a situation where can we at least try to identify the repeat players who are maximizing these benefits and at least give it to them, and then we can figure out where this gray area is. But there's no doubt there's going to be a gray area. But what we don't want to see is the court saying, or the legislature saying, because anybody could potentially have all these rights, and then our system falls down. If everybody doesn't have to testify before our grand jury system collapses. That's a problem. So we're not going to give this right to anybody. Or there's a Supreme Court case about some stories started coming out of this local jail that there were cruel conditions and that there was an inmate suicide and there was problems. And some journalists wanted to have access to the jail. And the warden basically said, hey, we're running a jail here. We don't just let people off the street come in and take a look at our jail. So no, nobody gets in. And the court agreed with that. And the court basically, again, said, we're not going to look at whether it's a reporter who's trying to gather news about an important government function, about whether our jails are, cruel and inhumane, or it's just some interested, curious bystander who wants to walk in. We can't make that decision, so nobody gets in, and we all lose out on that story and on that news gathering. So yes, I have no doubt that there are plenty of gray areas where it's like, boy, I sure wish we could give the right to this person, but maybe they don't fall quite as having shown that they have done this consistently enough, that they've reached a broad enough audience. But I also think there should be a way that if they keep doing it, that their audience can grow. SCOTUS blog is a great example. In sort of the beginning, it was just sort of this service for a law firm to talk about the Supreme Court. But now they had almost 20,000 people yesterday on their site waiting to hear about the Supreme Court. Without a doubt, they're delivering news to a broad audience in a timely manner. They are being the press. So they're functioning in that way. So at what magical point did it happen? I don't know. I don't think we should get so hung up, though, on line drawing, like I said, that it stops us from giving these important protections to people who could use them.
So, Bennet, if I'm reading your comments that you sent us before the show correctly, I'm guessing you have a little disagreement with Sonja's premise, and that your position might be more in line with Dan Gilmore, who has historically talked about we should be acting at whether the act in question is an act of journalism and paying less attention to who the actor is and what their journalistic track record is. Am I getting that right for you?
Yes, and that's just not true in this context. I mean, in the internet space, we often talk about the Federal Trade Commission. And you look at their statute. It's, they're celebrating their 100th anniversary this year, and it's as simple, to regulate, fraud and deception in internet commerce, and or unfair business practices in internet commerce. And that's simple. It allows them to evolve and deal with actions. And I found that in my dealings with Congress and trying to explain technology issues, where they make mistakes is when they attempt to define technology and not define conduct. And it seems that that's always the problem. And here we're bogged down on who is a journalist and who isn't, versus what are they doing? Are they doing something that would merit protection? And I always think that if a conduct approach to policy making is a sounder one.
Right, and you point out, I'm not going to, you're probably not going to blow your own horn on this, but you do a great show, as we mentioned at the top of the show, along the lines of ours, the Cyber Report, and you're up for a couple of really prestigious press awards for your show just this weekend, it sounds like, Sunday night, for Best Public Affairs Talk Show against Warren Olney, and against Chris Hedges for political commentary at the LA Press Club Awards. So you and our show and lots of people out there, I think, are good examples of people in the gray area of, what the heck are we doing here? Is
right.
Sitting and talking about recent Supreme Court decisions. Does that constitute journalism? Certainly, we hope getting good information out there. I certainly would want to have a lot of powwowing and consultation and hand-wringing, if necessary, about whether we do each week on this show constitutes journalism from a legal and constitutional standpoint and a shield law kind of perspective. So as far as drawing a line of any kind in order to get this a shield law in place, do you think that's wise or no?
Well, I mean, I prefer not, but yeah, having a shield law is better than not on balance. But, I just think I'm troubled by the line. And, the funny thing about, SCOTUS blog is, before any journalist writes a story, before, it may not be the first place to go, before that story gets submitted to the editor, they've consulted SCOTUS blog more likely than not. And so, if they're deciding that's not journalistic, I don't know what is.
Right. Sonja, help us understand why line drawing is something that we need to get used to and get our arms around here so we can get something in place.
Well, as I said before, I think that it's just been always the thing that stopped us from having any kind of press protection. It's what made the Supreme Court basically spend, the last 100 years reading the First Amendment, sort of with its thumb kind of over the press clause part of it, because we didn't want to get into it. So I first just want to get people over sort of that hump. And I also would say about sort of whether your show is, the press. And part of it is you might not need to be. I mean, you might for the reasons I would consider, I don't know how often you have a confidential source, how often you need access to, an accident site because you're there to gather the news, or how often you're going to go undercover and you need to make sure you're not going to be charged with fraud. Or, I think a lot of people out there, their speech rights are absolutely ample, which again are wonderfully robust and happily so for what they want to do, which is very valuable. It doesn't take it away, but it just means that we actually, they're doing what they need to do really well, really happily, without having the title of press, so that they can get the press rights that would possibly be out there. So maybe, to some extent, we're looking for the people who actually need these kinds of protections, and so we can give it to them. And that's just simply not everybody. That you can be doing something very valuable via your speech rights, and that doesn't mean you have to say this is the press. But we have some show who is doing these things, could use these things. Then I do think it's perfectly appropriate to sort of look at the record of saying, is this what they've been doing? Have they been functioning as the press? Have they been reaching a broad audience? Have they been doing it about these sort of regularly about sort of newsworthy matters, which is a term of art that the courts have used before and have some familiarity with, and we can look at this past and say, yes, you are. And maybe you weren't 2 years ago, but maybe you are today. And I think we're going to have to live with that sort of ambiguity. But at some point, you're fulfilling those functions, and you're in our crowd that we would like to protect. But again, we all have these speech rights wonderfully so that actually makes this less scary, because if we conclude the show isn't the press, you're still really really free to talk about all the information that you want to talk about.
Right. And I think there's a distinction between trying to come up with whether the show is the press for sort of commercial purposes, who's granted access to, say, a conference at a press rate or on a press pass, that kind of thing, and whether someone is considered the press for legal or constitutional purposes. And maybe you should enumerate for us, for everyone who might not know, what are, hopefully the SHIELD law will pass, and the press will have a federally recognized right to protect sources. But what are the other additional non-speech protections that the press already enjoys?
Well, right now, nothing. The press doesn't enjoy other protections, which is part of the problem. But like I said before, the areas where there could be potential need tend to come in news gathering. That's where we have this issue. So we do have cases that come up where we saw sort of the press wants to get access to a scene. In my article, I talk about the Occupy Wall Street. We had reporters who were being arrested, and they're showing their press credentials, and they're getting arrested with everybody else when they were there to try to cover the story. But we don't care. We don't look at what they were there to do or who they are because we don't separate this kind of issue. So access issues, access to information, access to government meetings. A lot of this stuff is given to us now statutorily, but there's no constitutional constitutional right of the press to have access to try to figure out what it is that the government is doing. So it's good that there's statutes there, but they could be broader or they could be taken away, which is a concern. The press is protected only by statute, not by constitution, to not have a search warrant issued on their newsroom, to just go through all of their files in their computers. The court rejected that as a constitutional matter, but the Congress came in and passed a statute there, which is great. But then, of course, we've had these more recent issues where we've had a reporter being named as a potential aider and abettor for receiving leaked information, so potential criminal charges. We don't look at that any differently than we would anyone else. And we, of course, had the administration getting information about reporters' phone calls and who they were calling. So we now live in a situation where we have reporters who are, they're like the drug dealers on the wire. They're using burn phones. They make a couple calls and they have to throw their phone away because we don't give them any special rights in terms of not having they're looking into who it is they might be calling on their phone. So, and then of course, like I said, undercover issues. If it goes undercover, but to do so, they need to sort of not be honest about who they are or why they're there, and then they get a job. They could potentially be liable for fraud or for breach of duty of loyalty to their employer because we don't care that they were a reporter who was trying to gather a story. So these are the areas where we could potentially have protections. Rights, though, of confidential sources has always been sort of at the forefront. It's always been the main one that people look at. But that also tends to include not having to testify about your observations. You're a reporter and you just go and you see people do things. You don't want law enforcement to call you in and suddenly you have to go on the stand and testify, because that makes you kind of just like a cop. It makes you just like an arm of law enforcement. You're a reporter. You're there for a different reason. So you don't want to have to be called in. So reporters are fighting for that right as well. So there's a host of news gathering issues that come up with reporters for which they have no rights that are any different from anybody else, which tends to be pretty minimal.
Right. I really encourage people to go and read Sonja's article in the Harvard Law Review. It's really nice that Harvard Law Review articles are out there and available for everyone to read on their own time and for free. So go check that out. We have the link in our discussion points. And we have another speech story courtesy of the Supreme Court. I think the technological tie-in with what we've been discussing about, who is a member of the press in the digital age is quite apparent, doesn't need a whole lot of discussion. I'm sort of struggling to find a technological tie-in, and I think I've got one for the McCullen versus Coakley case in which the Supreme Court struck a protesting buffer zone around a Massachusetts abortion clinic. And my question for you, Sonja, since we have you on as a resource to help us understand these speech and First Amendment issues, do you think this decision was correctly decided? And why wouldn't a buffer zone around an abortion clinic, I'm not a First Amendment lawyer, but anecdotally and perhaps from my law school career, I have in my head the notion that you can curtail speech if there's a clear and present danger. It's okay to stop people from yelling fire in a crowded theater. So why doesn't speech around an abortion clinic where people might well come to blows with each other or otherwise have an incident, why wouldn't that fall into that category?
Well, you see the court here really having some very different opinions about what happens outside an abortion clinic with these protesters. So on the one hand, of course, we have incidents of violence, of aggression, great aggression. There was a shooting in Massachusetts, which was what sort of led initially to this buffer zone law being passed. Very violent issues of public safety, which the court, at least in the majority opinion, completely recognizes. But then the court also talks a great deal about, and particularly the dissenters, about a different kind of protester, a protester who feels very strongly against abortion and wants to try to talk to the women who are entering these clinics. They're often described, particularly by Justice Scalia, as this very sort of gentle counselor, grandmotherly person who wants to go up to the women and say, dear, can you reconsider your decision? Let me talk to you about this. And so it is the concern of sort of the more gentle protester that is giving pause to the court here. And indeed, the petitioners who were, surely selected for this case fall into that second category. So the concern is that they are not being allowed to say what they want to say in this particular area, even though they would not cause any kind of public safety issue. They simply want to make their views known about this issue that is of great importance to them, and that is a free speech violation. And so the court had upheld other kinds of zones, an 8-foot sort of floating zone before, back in 2000, and saying, you can't get too close. But this was a 35-foot zone, and so the question was, I think, to some extent, was had the state proven there truly was this public safety issue to have this 35-foot zone to stop the more gentle counselor from coming, or were there ways to use other kinds of more narrowly tailored approaches to simply weed out the more aggressive or potentially even violent protester. So that's how the majority saw it, that they didn't make their case that this couldn't be more narrowly tailored, and that they're infringing on the rights of these speakers who are not the violent ones, who are not the ones who are going to cause this public safety issue. The court, of course, is having a lot of criticism because it does allow buffer zones in other type of situations. It upheld buffer zones around funerals in the Westboro church case. It upheld buffer zones around its own court, around political conventions. We have free speech zones in other kinds of situations. So there's a criticism about do we allow having these zones in particular areas or not? And I think that's really one of the key questions about this case.
My question, bringing in the world of social media and the internet, had to do with whether the court considered, now I have not read through this one of the court's decisions this week, whether the existence of other avenues of speech, such as we see today, played any role in the decision, and how that impacts the need to make proximity such an important component of protest. I mean, you hit on something that I think answers that question, and that is the gentle protester who needs to actually face-to-face try and confront someone, that's their expressing their speech rights. That seems like an awfully aggressive speech right, perhaps, but I was curious about whether the existence of other avenues of speech and digital speech played any role in this decision, or should play a role when we consider buffer zones.
Well, the court did talk about how the public property is different, our public sidewalks. That was one of their concerns here, was that this included speech on the public sidewalks, and that when the court tells us we have just had a tradition that you have to deal with speech that you don't like when you're out on the public property. And they compared that to they talk about, if you're on a website you don't like, you can just click off the website, or you can churn the channel on your television, or you can do these other things. And they say that you get to do, but when you're out in these public properties and you come across somebody who has a message that you don't like, you don't get to churn them off. So in a way, it's not so much the existence of the other social media as saying you had other ways maybe that you could have made your point. They actually say you can go to those other forums and just talk to the people you want to talk to, and you don't have to deal with the messages you don't like. But that's not the case when you go out in public. If you're on the public sidewalk and somebody has a message you don't like, you don't have to look at them, but you can't turn them off. And so they compared the two in that manner, that it's still sort of a more in-your-face world when you're out on the public sidewalks.
Yep, that makes sense. I sure hope they didn't bring up television knobs again. in the McCullen case.
I don't remember knobs, but I think there was a turn the channel reference.
It was a knobby week at the court. All right, let's move on to a development in California that we've been following just to bring you up to speed. The revenge porn case that we've been watching, and I'm pulling up its name here, so we always have trouble pronouncing his name. Kevin Belaert is how I'm going to say it. Of You Got Posted. Is going to go to trial, that the case can go forward. There's enough evidence, and he's being criminally prosecuted, felony counts of various things. What I'm not clear on is whether the Revenge Porn Act itself is a felony or misdemeanor. Evan, are you any more clear on that?
Whether it's whether him do it was more like the extortion, wasn't it? That he'd done identity theft and extortion. I don't know that it actually had to do with the posting of the pictures. Well, I mean, in as much as the posting of the pictures would be one of the elements of the crime of extortion. But
right.
I think it's more nuanced than just saying he broke the law by putting these photos on the internet.
Yeah, I think you're right about that. But he's going to trial, and this will be, I think, a important case to follow in the world of criminal liability for taking these steps. I know this is something that comes up in your practice, Evan, and I'm just wondering if you have an opinion on this case going forward.
Well, I mean, revenge porn is an awful, terrible thing. It ruins lives. It causes people to commit suicide. So it's, definitely a scourge, and it's got to be treated somehow. And if you read the works, particularly of Danielle Citron, she very artfully, very forcefully, and very legitimately, articulates some of the ways in which it can be proscribed. But there is a First Amendment concern here. Sort of just to tack on you don't have the right to exist in a world free of all speech that is unfavorable to you. So I'm certainly not going to go over to the First Amendment side and say, yeah, all revenge porn sites should be protected by the First Amendment. All I'm trying to do is underscore the critical importance here of this content regulation, this regulation that would prohibit content like this, and just show what an important issue and what a fine line there is to draw here, and very problematic. And of course, there's the whole issue of Section 230, and whether that should whether and to what extent that immunizes this conduct and this facilitating of content. And the Supreme Court has said you don't just because you're an intermediary doesn't mean you're always going to be protected from direct liability. So maybe it's a new world that we live in. Who knows?
Right. And over at Ars Technica, they point out that in California, we have a new law that could conceivably apply in this case, but Belaert is not accused under the fact that it's now a misdemeanor to post identifiable nude photos of someone online without their permission in California. So, Sonja, any thoughts on the revenge porn case going to trial?
Well, I think, like Evan said, that it's certainly very, problematic area of speech law. I agree that there are speech interests there, but I think it fits. I tend to agree with Danielle Citron, because that it fits easily, I think quite easily, into our First Amendment jurisprudence, where we have exceptions when there are narrowly tailored restrictions to strong state interests. And we have strong state interest here in having states wanting to pass laws that protect their citizens from having these kinds of traumatic privacy violations done to them. So this seems to fit within that for me. And certainly to the extent, again, going back to privacy, which we talked about with the Riley case, that as we have this increase, interest in privacy and recognition of privacy, that if this isn't private, I don't know what is. Sort of, it's Danielle Citron refers to it as non-consensual pornography, and how the privacy interest there seems extremely strong. The state interest there seems pretty strong. So as long as it's a sufficiently narrowly tailored law, it seems to me like it could go forward.
Denise, I know you want to wrap things up here soon, so I don't want to prolong this more than necessary. But okay. I agree with you, Sonja. It seems like we could easily craft legislation that's going to make sense in the abstract. But don't you think it's going to be difficult in really trying to apply that as to whether a piece of content qualifies as having violated the statute? And I don't want to get too graphic, since ostensibly this is a family show, right? But a photo of someone in. Well, I won't be sexist about it. I'll say, a photo of a dude in a Speedo. Or I won't be sexist against women again, in the social.
Could it? We know you're wearing one right now, Evan.
That's
so just
right.
Stand up, model it for us.
I try to bring that up every episode. I'm not going to stand up.
Thank you.
When it comes to evaluating particular pieces of content and the effect that it has, isn't that going to be where the real difficulty is in all this? Maybe not in crafting legislation that will put the offensive conduct vis-a-vis the content in a very apportioned space so that it's not violative of the First Amendment. But it seems like as applied, this is going to have some real problems whenever it comes up.
Yeah, I think you're right. And again, sort of definition issues, they really are, they keep coming back as our pickle. And we have, of course, struggled with how to define pornography in general. And we could possibly sort of take from some of that, but even that definition is problematic because it changes from community to community, which is clearly a problem today. So no, I agree. I think that could be an issue that we could have sort of as applied problems of there wasn't sufficient notice that this particular type of a photograph would fall into this category. I think that's a good point.
Hey, Bennet, I know you've covered this on Cyber Report, and I think we're back to another situation where Professor Goldman, for example, has criticized the California law that I mentioned a moment ago as being something that we don't actually need, that existing laws can be used to prosecute people like Kevin Bollert. But your point is that a new law that improves things a little bit is of great value, and we should go forward. Is this another situation of that?
I think so. I mean, here, this is a case where they're being prosecuted under existing law. But the new California law has value because you keep hearing this whole meme about the internet being the wild, wild west, and people don't know that you can't do a lot of these things. And so sometimes going through the exercise of even tinkering with existing law just to make clear that something is unlawful, people forget law has a normative purpose. Law is an exercise in society is saying this is where we stand on these things. These things are unlawful. We do not permit them in our society. And so that alone, I think, has value. And so going back to the earlier point Evan was raising, I think the California law addresses this. I think there is a way to address this, and it goes on the issue of what was the person's expectation when these photos were taken or this video was taken. And although we have a complete carve out for Speedos, but I think I don't want to see any, frankly. But I think that if you focus on what did the person or the victim think that this would ever be put on a nationally viewed or worldwide viewed website, and did they have an expectation that this would not be shared? And I think that's a legitimate way to address the statute.
All right. Well, I think we're going to do one more story here. There's lots more we could discuss, but we're going long already this week with all the great decisions out of the Supreme Court that we've had to chew over. Though I can't really end the show without talking about monkey parking, which is something that Bennet set in and has to do with the legal pitfalls of social parking apps, and so impacts the social web.
Monkeying with the machine.
Yes, and the city of San Francisco is monkeying with an app called Monkey Parking, which was basically allowing people to share information, they say, crowdsource information about where available parking might be. It's sort of a sad statement on the free market economy in a way. I mean, I'm sure that the people who are out there slogging around trying to find parking places and then communicate that they're available or not, in the most upper of socioeconomic strata. But, it's a way to make a little extra cash, maybe better than spraying down somebody's windshield and washing it, maybe potentially quite lucrative, who knows. But the app basically allowed people to post, hey, there's an available parking place here, and I will give it to you. And I'm sure there's payment involved somehow. I'm not quite sure how the app works, but the city of San Francisco said, you're not going to be able to save parking places for each other using an app. The company thinks that it wasn't doing anything illegal, that all it's doing is sharing information. So, Bennet, do you have anything to add here? Who do you think's in the right?
Well, I think probably the city, but I know in San Francisco, there's some people have it and some people don't. Parking karma or parking mojo. And so they are depriving those people of their property right and their unique and special ability to have parking karma or mojo. And and I love the photo you show with the meter fail. I think I get that one a lot. But and so ultimately, I think the city does have an interest in making sure that spaces aren't being tied up, and that there's even broader reasons. A lot of energy is wasted by cars, just looking for parking spaces. And so, I think that they have a right to regulate, the sale of something that is their product.
I wonder if this impacts speech, Sonja, that you have a free speech right to communicate where an open parking place is, but does that also mean you have the right to put yourself or something in the way to save it for someone who's used an app to come find that?
Yeah, the problem with speech is that everything really can boil down to speech. So we always have this issue. There's always a speech interest somewhere. And so to the extent that we're talking about people saving these rights and then these spaces and then getting paid for that in a transaction, it makes me think of how, if someone says, I'll give you so much money, will you kill my wife? We don't say, oh, that's a speech right. We say, oh, that's a crime. And we don't just get all hung up in the idea that this is speech. So to the extent they're sort of proposing a financial transaction that the city doesn't want them to do, I don't see the speech right having a strong interest. If it's just telling people, hey, there's some free spaces here, sharing that information, that becomes more of just, why not? Why can't you share this information? And there are all these other apps that talk. It makes me think about sort of telling people about speed traps, and they don't like that. And there's apps that will tell you, and everyone puts in there that I saw a speed trap. Tell everybody there's a speed trap here, or just even flashing your lights. Is that speech that you're telling them there's a police officer behind and coming up, and they don't like that kind of speech. And then maybe you have a little bit more of a speech interest, but it's probably could be outweighed by the city's interest to have these spaces used efficiently. But the speech interest here is I think pretty minimal overall.
All right. Well, we're going to move on here to our tips and resources for you this week and wrap up the show. I'm afraid that our tip, by the way, I'll just chime in on the prior story before we let it go, that this whole show has been very nostalgic for me for my law school years, because when I was in law school in San Francisco, going to Berkeley, you could not get at the Harvard Law Review online, and now you can, so that's a good thing. And also when I was living in San Francisco and going to Berkeley, you could not have an app tell you where to park, and that was a very bad thing. So I'm sure that there are people really rallying around monkey parking and hoping that they manage to pull this out somehow or another legally. We'll keep an eye on that. So our tip of the week is not much of a tip, because I don't think we're going to find consensus. Evan sent in another, I won't call it a law review article. This is the humorous law review, right? The green bag, it is called.
In the style of a law review article.
Yes, in very much the same print and font and format style of a law review. And this particular green bag piece has to do with the pronunciation of, I'm going to say it the way I say it, and that is certiorari. But lots of people say it differently, and there apparently is not even agreement on the Supreme Court how to say that word. What the word means is the grant, the permission, the affirmative statement by the Supreme Court that they're going to hear a case. So I figured I'd poll everyone on their pronunciation. I gave you mine. Evan, what's yours?
Shashandarandu.
Okay, Evan's just gone to India for us for a moment. How about you, Sonja?
I say certiorari, which apparently had a small plurality of the justices. But
yes.
Yeah.
I'm close. I just kind of take two of those syllables and put them together. How about you, Bennet?
I usually just say cert.
Cert. There you go. Say cert. That's our tip of the week. Just say cert and everyone will know what you mean. If you want to see a really funny rundown of the various approaches of the Supreme Court justices and others, then check out the Green Bag article that's in our discussion points. Our resource of the week comes from Daily Dot, is very timely, based on the Riley decision. It's called "What to Do If Police Try to Search Your Phone Without a Warrant," and points out that it's going to take some time for the memo on Riley to get out, and that the 7.5 million sworn police officers in the U.S. Might take some time in realizing that they need a warrant to search your phone during an arrest. And so this tells you what to do. First of all, definitely use that lockdown screen if what you're trying to do is protect your phone. And then the various steps you should go through if someone is trying to search your phone without a warrant, with the most important being just, if they insist on going forward, there are ways of expressing that you don't consent to that, and making a record on it. But if it goes forward anyway, that you should just leave this to the courts to sort out. And I think this is either someone from the EFF or ACLU that's being quoted here, saying you're in an arrest situation, you have no power, and you're just going to make the situation worse if you really try and make a scene about it. So you have to wait for the court to fix any injustices that are taking place. This is great advice in the wake of Riley on how to make sure that you're making a record that you don't consent to the search without a warrant, but you're not doing something silly either. So thank you, Daily Dot. I enjoyed that piece. And I've really, really enjoyed our conversation today on Twill. So much to cover. We covered much of what we wanted to, not all of it. So hopefully more topics for another day. But it's been such a pleasure having the wonderful insights and wit and intelligence of our panel today. Bennet, Kelley, great seeing you again. Definitely check out Cyber Report. Anything else that people should take a look at, follow along with you? We've been putting your Twitter up the whole show. Internet Law Center is your site. Anything else you want to let us know about?
No, just Internet Law Center and Cyber Law Radio. Those are the two sites to check out.
Great. Thank you so much, Bennet. Sonja, wonderful to meet you. Love your colleagues down at University of Georgia School of Law, and you. Next time I'm in Athens, we'll have to have coffee.
Absolutely. Thanks so much for having me. This was fun.
Really fun having you. Thanks so much for all your insights on the difficult issues that we have gone through today. Evan, phew, this was a big one.
For sure. Yeah, we've been looking for this for a while, but yeah, I don't think, I certainly don't feel let down. It was a fun conversation. And I tell you what, Denise, I mean, if I had to go back in time, I would certainly apply to University of Georgia Law School if they'd let me in,
Absolutely. And I didn't, I stuck these in our discussion points. I'm not mentioning them now in great detail because we're out of time already. But if anyone wants to look at the Law Street media ratings on top law schools for intellectual property law, we've got those there for you in the discussion points. And University of Georgia should be in there. They're not in the top 10, but they've got to be there somewhere on the list. And University of Santa Clara.
Eric.
Sorry?
I was saying congratulations to Eric for being number 2.
Yes, exactly. Professor Goldman at University of Santa Clara, they tied for number 2, which is just fantastic. So we're going to get on out of here and let you and everyone else start enjoying their weekends and the rest of our programming here this afternoon at This Week in Tech at the TWIT network. So we'll just remind you that you can catch the shows after the fact at our website. That's at twit.tv/twill. Also on YouTube at This Week in Law there. And on iTunes and however else you'd like to find shows like this. We're going to be there for you, and come talk to us on Google Plus and on Facebook and on Twitter. We love hearing from folks about your thoughts and reactions and insights, the funny things that our discussions make you think about, and how you pronounce certiorari, or however you'd like to say that word. What else? You should email us. We can't promise that we're going to be able to shield confidential sources, but you should email us anyway if you have something that you don't want to just splash out to the world. Evan is Evan at twit.tv. I'm Denise at twit.tv. And we love hearing from you. We love hearing from you from any and all channels, suggestions for guests. It's just so wonderful to have the audience that we have and the enthusiasm we have for the topics we discuss. We just love doing the show. And we're going to do it again next week at 11 o'clock Pacific time, 1800 UTC. So you should plan on joining us then. Thanks so much.
Not next week. Not.
Oh, that's right. That's right. Next week is 4th of July. Thank you, Evan. So we're taking a break. So. The whole network is taking a break on the 4th of July, but we'll see you the week after here in the United States. Have a safe and happy Independence Day, and we will see you on the other side of that. Take care, everyone.